Today we will discuss some topics that have been going on, such as Young Slime speaks on taking MarrV gun 2 times, Lil Dude beefing with 2 Philly rappers, and we will also get into JG Wardy's Snitch revealed and more. The first topic we will get into is Young Slime speaks on taking MarrV guns. Recently, a Young Slime phone call would be leaked of him being interviewed by some fans so he can buy some more fentanyl perks. And in the phone call, that would be posted by former Paradise rapper Wardy. Young Slime would say that first time he took MarrV for bad was back when their man Fat Swag died. And the second time would be recently. Wardy would put a caption over the video saying, "Nick, then had they run, it's over. I heard you was talking, you was never a cool kid. Twice 2 times ran off." He would then tag MarrV and say he's sweet. MarrV would then respond and deny the allegations of being robbed by Young Slime 2 times. Do you think MarrV getting robbed by his own man 2 times could end his rap career? The streets would also talk about how Wardy Real Live started and ended Marvin's career, saying he was real live. The main one saying MarrV chased Dizzy in his songs and saying how active he is. Now he's saying MarrV and be getting bagged for his iron crazy, how the tables turn. The streets would react.
The first time he taken it, that was Fat Swag that.
You took my gun 2 times?
Yeah, he did some goofy blood, you know, and I took that slider up. Then the second time, I can't tell you the second time.
Nah, what's the second time? Hold, bro. This recent? This recent?
Yeah.
Oh my God, I ain't gonna lie, don't tell me. He's sweet. I ain't gonna lie. It really hit different when niggas not alive.
For the next topic, we will discuss Lil Dude versus Philly. Recently, a Philly rapper who I've discussed on here before for beefing with uptown rapper AC640 would began beefing with another DMV artist. And this time, he would beef with rapper Lil Dude. The Philly rapper would go by Tovey, and Tovey would post a diss to Lil Dude saying, when he turned 40, if he anything like Lil Dude, he'll just off himself. And another Philly rapper named OT7 Kwani would repost Tovey post too. Dude would respond to the 2 Philly rappers saying, "Who is Tovio and who are these Bamas?" He would then follow up saying, "All you fake crazy emo rappers keep wearing all black, not showering or face and ski mask on backwards. All this dumb nigga gone beat down leg." The streets would begin to do their research on Philly rapper Tovey, and some messages would be leaked of him allegedly being into freaky stuff. And he also says that he didn't mean to poop on her finger when he had her playing with his butt. After this, Tovey would go black. Do you think DC and Philly should put the beef aside to make some music together? The streets would react to Tovey and Lil Dude. And for the last topic, we will discuss J.G. Wardy's Snitch revealed and more. Recently, a full 92-page testimony would be released of the Snitch and J.G. Wardy case. The Snitch would go by No Rats Allowed. On Instagram, real name Emmanuel Reed, J.G. Wardy lawyer would also file an appeal for the rapper's 35-year sentence. Now we will get into the testimony of Emmanuel Reed. You have heard evidence that Deontay Eric Wiley and Emmanuel Dwayne Reed entered into a plea agreement with the government pursuant to which Deontay Eric Wiley and Emmanuel Dwayne Reed agreed to testify truthfully in this case, and the government agreed to decline prosecution of other charges against them to bring Mr. Wiley and Mr. Reed's cooperation to the attention of the sentencing judge and to consider filing papers with the judge which would permit the judge to impose a more lenient sentence than she might otherwise be able to impose. The government is permitted to enter into this kind of plea agreement. You and Tom may accept the testimony of such a witness and convict the defendant on the basis of this testimony alone, if it convinces you of the defendant's guilt beyond a reasonable doubt. A witness who has entered into a plea agreement is under the same obligation to tell the truth as is any other witness. The plea agreement does not protect him against a prosecution for perjury or false statement, should he lie under oath. However, you may consider whether a witness who has entered into such an agreement has an interest different from other types of witnesses. You may consider whether the plea agreement the witness entered into with the government has motivated him to testify falsely against the defendant. The testimony of a witness who has entered into a plea agreement should be considered with caution. You should give the testimony as much weight as, in your judgment, it deserves. Q. Just so that we're clear, when you say drugs, are you referring to marijuana or are you referring to Percocet? A. Marijuana. Q. You've never seen Mr. Willis pop a pill? A number Q. You've never seen Mr. Willis sell any Percocets? A number Q. You've never seen Mr. Willis buy any Percocets, isn't that correct? A number Q. So how can he be the head of an organization that, in your words on direct, you say that you all were selling Percocets? A. I said Mr. Willis wasn't selling Percocets. Q. In fact, isn't it true that Mr. Willis did not want to sell anything but marijuana? A. Yes, sir, that's true. Question. You also stated that Mr. Willis's mom took you into her home, isn't that correct? A. Yes, Q. She clothed you, didn't she? A. Yes, Q. She fed you, didn't she? A. Yes, she took care of you like you were her son, didn't she? A. Yes. Question. And Mr. Willis, later on in life, he did the same for you, didn't he? A. Yes, he took care of you. He gave you money when you needed it, didn't he? A. Yes. Q. He even cut you discounts on pounds of marijuana, if you needed it, didn't he? A. Yes. Q. But you sit here and you say that he's the head of an organization. Do you still believe that? A. I don't know. Question mark, Mr. Reed. It's true that in the face of all of that, that unrelated to that, it doesn't go to that. It goes to his character. I don't know what else it goes to. And I don't think you can bring in a bad act, prior bad act with respect to a witness's character and confront him with it, Mr. Clark. Even in the face of the government saying yesterday, asking him if he's ever shot at someone, if he's ever the court. I think it was all in connection with if he'd spun. Mr. Clark, say that again. The court. I think it was all within his gang activities. Mr. Clark, they just asked him, have you ever shot at someone? Have you killed someone? Mr. Nelson, we did specify and asked, were you punished by the gang for what you did? Number, were you celebrated by the gang for what you did? Yes. That was the line of questioning. It was all tied to the counts. In the conspiracy charged in this case, which he participated in and pled guilty to participating in. They're apples and oranges. The court, you still haven't told me, okay. When you get to your closing argument, what are you using this evidence for? What does it prove? That he's a bad person? Doesn't prove he's a liar? Doesn't go to his credibility? It's not a conviction, Mr. Clark. They're trying to say he's out there shooting people in furtherance of a conspiracy. This particular point makes it clear that he is indiscriminately. There's no reason why he would be shooting his baby mother in furtherance. Or shooting around. Shooting in the area of his baby mother in furtherance of the conspiracy. It goes directly to that issue. They brought it up. I didn't bring it, they brought this into this case. The court. Well, you said, you've always been selfish. You've always thought about yourself. And then you said, and that's why you shot at your baby mother. I think we're going to strike the question. And think you can ask. Ain't it true that there were times when you carried the gun, where you pointed the gun when it wasn't part of PDS and that's it? And then you go on. I think he can ask that, given the way he testified on direct. So, Mr. Clark. Now, if he says no, though, I should be able to then bring in, if he says, the court. Well, was he convicted of it? Mr. Clark. It's a misdemeanor. Misdemeanor conviction. Mr. Nelson. Misdemeanor domestic violence. The court. All right. Just what are we trying to use it for? Evidence of a witness's character. Rule 607, 608, 609. So let's look it up because it doesn't seem like you have. Mr. Clark. I don't have my book. The court. Except for a criminal conviction, in Rule 609, extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support the witness's character. The court may, on cross-examination, allow them to be inquired into if they are probative of the character for truthfulness or untruthfulness of the witness. I don't see how this goes to his character for truthfulness or untruthfulness. Mr. Clark, even though the government yesterday, at least in their questioning, it seemed like whenever he was carrying a gun, wherever he was shooting at someone, it was always about PDS. That kind of ties into the selfishness. The court. I think you can ask the one quick question that I asked you. You know, isn't it true that you've also carried a gun when it wasn't for PDS? Mr. Clark. The only reason I'm uncomfortable with that part because it assumes the adverse is true, that he was carrying a gun for PDS. So I think if I can clean up. Because I understand what the court. I think it's so prejudicial and it doesn't go to his truthfulness. And you really shouldn't be bringing in specific instances of misconduct just out of the blue in a question. And I'm going to strike the question. And if you want to probe about what he said on direct and say, sometimes you carried the gun just for yourself, separate from PDS, you can ask that. But I want it very, very tailored. We're not pointing guns at baby mamas right now in this courtroom. There was a lot of discussion in one of the jail calls. It wasn't your client. It was Mr. Kirsch's client, where he's talking about hitting somebody upside the head, his email. And everything doesn't walk into this courtroom, even though they said it. You know, everything people say their character isn't admissible, Mr. Clark. But Mr. Daniels is a defendant versus the witness. But I understand the court's point. The court. I just think that's not something you're allowed to ask him about. If you would have teed it up first, can I ask him about this? I would have said, does it go to his truthfulness? And it doesn't. And that would have been the end of it. Mr. Nelson, I think it might be a good time for a re-reminder of the instruction you just gave the jury, Your Honor. The court, I just gave it. Mr. Clark, I don't mind if the court wants to give it again. The court, I just think it just highlights it even further. Open court. The court, all right, that question is stricken from the record. Let's ask another question, Mr. Willis. Mr. Clark. Mr. Clark, Your Honor. By Mr. Clark, Q. On direct, you testified that you carried a gun and shot at people for PDS. Isn't that correct? A. Yes. Q. It's also true that there were times when you carried a gun and shot at people when it was not for PDS. Isn't that also true? A. Yes. Q. There's also been times when you've carried a gun and pointed it at people who you believed were members of PDS. Isn't that also true? A. Rephrase your question. Q. There have been times when you carried a gun and pointed a gun at people who were members of PDS. Isn't that true? A. Yes. Q. On direct, you claimed that you stopped hanging around PDS trap houses around 2019. Number Q. Was it 2021? A. Yes. Question. And so the raid that occurred in 2019, that didn't force you to stop hanging around PDS? A. Rephrase your question. Q. Yes. So there was a raid in which you were present in 2019? You testified to that on direct. Correct? A. Question. And after that, did you stop hanging around PDS? A. Somewhat. Q. Okay. And you started selling marijuana outside of Holiday Market, isn't that correct? At an Exxon gas station? A. Yes. Q, and when you were selling marijuana outside of Holiday Mart at Exxon gas station, you didn't need any authority to do that from anyone from PDS, isn't that correct? A. You said two different places. Q. At the Exxon gas station, I mean. A number Q. You didn't need any authority to do that, isn't that correct? A number Q. Okay. And that was a mutual territory, isn't that correct? A. Yes. Q. And the proceeds that you received from those sales, that went into your pocket, isn't that correct? A. Some of it. Q. All right, but you were off on your own doing this. That's correct, right? A. Yes. Q. You would consider yourself to be an entrepreneur? A. If that's what you call it. Q. What would you call it? A. A hustler. Q. Okay, but by yourself? A. Yes. Q. Okay. Just like when you were out there selling Percocets, you were doing this by yourself? A. Correct. Q. There's no agreement with anyone else to sell Percocets? You were doing this alone, correct? A. Correct. Q. Not with Mr. Willis, as you previously testified to. The number Q. All right. It's true that you also use Percocet, correct? A. Correct. Q. And when was the last time that you would say, prior to your incarceration in February of this year, that you used Percocet? Was it the same day, the day before, week before, month before? A. The day before I was arrested. Q. Was this something that you would use on a daily basis? A. Correct. Q. So would it be safe to say that this was a habit, your daily habit, to use Percocet? A. Correct. Q. You were initially incarcerated on February 13th. Isn't that correct? A. Correct. Q. And you really wanted to get out of jail quickly, isn't that right? A. Correct. You did not want to stay in there for 1 day, 2 days, 3 days, 5 months, nothing, right? A. Nobody want to be in jail. Q. That is correct, Mr. Reed. And so much so that you begged the government to let you out, didn't you? A. Correct. Q. You actually begged one of the attorneys sitting at counsel table for the government to let you out, didn't you? A. Correct. Q. You told them that, asked for full immunity and an immediate release from DC jail on home confinement with a 24-hour tracking device? A. Correct. Q. You also told them that if they were to let you out, you would become a lifetime confidential informant for them. Isn't that correct? A. Correct. Q. Did they let you out? A number Q. In fact, it's true that they're not willing to do anything for you at this time. Isn't that correct? A. Correct. Q. So, on direct, you also testified that there was some kind of point system for keeping score, right? A. Correct. Q. Was this like one of these boards, one of these charts, there was a scorecard, like in a basketball game? How was the score being kept? A. In your mind. Q. So you met with FBI agents. I think I'm counting, if I'm not mistaken, 8 times. Isn't that correct? A. If that's what it say. Q. Okay. During your first interview, which was February 26th of 2024, you spoke to them about this particular situation with a point system, didn't you? A. If that's what it say. Q. Do you remember the conversation that you had with them? A. Yes. Q. Okay. In fact, you didn't say anything about a point system. A. If that's what it say. Q. Would you like to refresh your recollection with that? A. Yes. Q. Okay. All right. If we can take it off the jury and the court. All right. So you're refreshing his recollection as to whether in that particular interview he did or did not talk about the point system. Is that what we're doing? Mr. Clark. Correct. The court. All right. So for that purpose, show it to the witness alone and ask him if it refreshes his recollection. Mr. Clark. All right. By Mr. Clark. Q. Do you see where I've circled? A. Yeah. Q. Is your recollection refreshed now? A. Yep. Q. All right. You can take it down. All right. So I'll ask you again. In fact, you told the FBI agents that there was no benefits? A. Yes. Possess a firearm, including a machine gun, in furtherance of a drug trafficking offense. Isn't that correct? A. Yes. Question mark. Mr. Willis is not on that conspiracy. Isn't that correct? A number Q. You also... The court. I'm sorry. He's not on it. Mr. Clark. He's not on that conspiracy with you, is my question. The court, can you come to the bench? Because I don't understand your question. Bench discussion. The court, what do you mean he's not on that conspiracy? Mr. Clark, he's not named in that indictment. The court, okay. He pled guilty to conspiring with people other than Mr. Willis, is that you're saying? Mr. Clark, no, I'm specifically speaking about the indictment. The court, okay, so he pled to an indictment. Mr. Willis is not charged in the indictment, is that what you're trying to ask? Mr. Clark, yes. Mr. Nelson, Your Honor actually pled to a criminal information and not an indictment. And in support of that criminal information, it stated quite clearly that Mr. Willis was part of the conspiracy to which he was pleading guilty to. I believe that Mr. Clark has now opened the door to us reading in that statement of facts with his question about the fact that Mr. Willis was not on the conspiracy, with his sort of sloppy, open-ended question about what that means. Mr. Clark, why do you have to say it like that? Come on, I think it's been, the court. Okay, Mr. Clark. I've just sat back and allowed him to speak like that to me for a couple weeks now. And just because I filed a motion against you for your sloppy questions yesterday does not mean that you get to talk to me however you want to. The court. Okay, that's true. We were doing pretty well for the first week. We need to get back to it. But I called you up here because I didn't understand the question. He was not on that conspiracy. So the conspiracy to which he pled guilty is set out in the information to which he pled. That's on my docket. It's a court record. I can take notice of whoever he pled to conspiring with in the information. And if the information just says others, then he pled guilty to a statement of offense that named people. And so I think that you have to be careful with that question. I don't know how he can answer it because I don't know what being put on a conspiracy means. I just don't think that's a term of art. So I think you need to rephrase the question. But if you rephrase the question to suggest that he did not plead to conspiring with Mr. Willis, and that's not true, then they're going to be able to bring in and lead him back on redirect to the effect that this is what you plead to. This is who you said you conspired with, etc. Mr. Clark, Your Honor, frankly, that's fine because he's already said he was not conspiring with Mr. Willis to sell oxycodone. Sue the court. Oxycodone. Mr. Clark. Right. The court. Okay, the conspiracy la chantros, but you just said he pled guilty to conspiring to sell marijuana and oxycodone. Mr. Willis was not on that? Mr. Clark, I understand the court. Okay. Mr. Clark, I'll just withdraw that line of questioning. The court, okay, all right. You can withdraw the question, and then if the question is withdrawn and it hasn't been answered, then you can ask him about the underlying facts. But I don't think you can go into the statement of facts unless he testifies inconsistently with it. That's the end of this video. Get this video to 400 likes for JG Wardy Testimony Part 2. Like, comment, subscribe.